Hello and welcome to the latest vlog from the Clinical Negligence and Personal Injury groups at No5 Chambers. My name's Neil Shastri-Hurst and I'm joined by three other members of Chambers, all of whom work in the field of clinical negligence and personal injury. First we have David Tyack, or should I say as of March of this year, David Tyack QC. David has extensive experience in high value and complex cases and undertakes work across the full spectrum of clinical negligence matters. He's also my go-to man for those tricky problems that inevitably arise in cases of this nature. Also joining us is Charlotte Robinson-Jones. Charlotte has experience across the full gambit of clinical negligence cases. She also has experience in the areas of deficiencies in the provision of care in nursing homes. And last but by no means least, we have Andrew Rhodes. Andrew joined Chambers as a full tenant in October of last year and is already building up a busy practice across his areas of interest, which include personal injury, clinical negligence and employment matters. Thank you all for joining me today to talk about the case of Bradfield-Kay and Cope, which was a case in which judgment was handed down last year. And it raises interesting questions around the tests in Bolam and Bolivo, and we'll be looking at the ramifications of the judgment on these. So before we delve in too deeply, Andrew, would you like to set out the background of the case?
Yes, thank you, Neil. So in this case, the claimant, Mr. Bradfield-Kay, had alleged that the defendant, Mr. Cope, who was a consultant orthopaedic surgeon, had negligently performed a total left hip operation on the 18th of December 2009. And there were also allegations regarding a subsequent consultation that took place in August 2010. Now, the claimant, Mr. Bradfield-Kay, had a history of neck and back pain, and he had osteoarthritis in both hips. And he'd previously undergone a total right hip replacement undertaken by Mr. Cope in November 2009. So it was decided also in November 2009 to proceed with the total left hip replacement, which occurred in December 2009. Now, unfortunately, unlike the previous hip replacement, the claimant didn't recover in the way he had previously, and he experienced pain in his thigh and groin. Now, there was subsequent consultation in August 2010 and some dispute about whether the claimant had in that consultation reported those symptoms to Mr. Cope and whether Mr. Cope undertook an examination. But as time went on, the claimant's symptoms got worse. He saw Mr. Cope again in February 2011, and Mr. Cope identified a painful clicking, which he attributed to the psoas tendon catching on the anterior part of the cup. And he informed the claimant's GP that if that continued, he'd consider a psoas tendon release. So the claimant's GP referred him to another consultant orthopaedic surgeon for a second opinion, Mr. Hamadi, and Mr. Hamadi performed a left hip revision on the 15th of March 2012, and he took some notes of that operation, and he noted that he found the cup to be retroverted, and the anterior of the cup was prominent and catching on anterior structures. And we see after the operation, the claimant's symptoms still did not improve, and he underwent a further hip revision in 2016. And effectively, I think that's a summary of where we are. There were three allegations in respect of negligence on the part of Mr. Cope, but I believe Charlotte will go on to address those. But yeah, that's the case in a nutshell.
That's great. Thank you very much, Andrew. So Charlotte, we've heard about the background to the case. Perhaps you'd like to set out what facts were in dispute and address what happened at trial.
Yes, thank you. So there are three allegations. Firstly, that the acetabular component of the hip replacement was prominent, such as the iliopsoas tendon caught on it, which caused the claimant to develop iliopsoas tendinitis. The second one, and I'll come on to explain, essentially the claimant was successful in that first allegation. He was successful in the second allegation, which was in relation to an incorrect femoral component being placed. And then C, the third allegation, was failing to take any steps in relation to the complaints of groin pain in that August 2010 attendance, and that was the one where the claimant was unsuccessful. But we're focusing, our more interesting point today is that first allegation regarding the acetabular component. As an interesting side note at this point, one of the early things the judge comments on in the judgment is that he'd heard from Mr. Chatterjee, who's a consultant orthopaedic surgeon for the claimant. And the judge commented that Mr. Chatterjee was an experienced orthopaedic surgeon, but he conceded that his primary focus was knee replacement surgery, although he had undertaken total hip replacements. Mr. Manctolo was the expert for the defendant, another consultant orthopaedic surgeon, and the preponderance of his practice was primary and revision hip arthroplasties. It was said that he was the past president of the British Hip Society, and he'd published widely in relation to hip arthroplasty. So the judge from the outset said, well, I formed the impression that because of that experience, Mr. Manctolo was better able than Mr. Chatterjee to speak to the practice of hip specialists in England. Now, there was quite a bit of agreement between the experts, really. So the first thing that's perhaps significant that they agreed on, they said, well, if the component is placed so that it catches the iliopsoas tendon, as it passes over the exposed rim of the cup, the tendon can be inflamed. That can lead to tendinitis, and here the claimant had developed tendinitis. It's a recognised complication of the surgery, but it was accepted here that the likely cause of the claimant's tendinitis was a prominent anterior component. They agreed that the component should face forward by about 15 to 20 degrees, 10 to 30 being in a reasonable range, but the X-ray suggested the amount of anteversion here was small and something in the region of 0 degrees. There was some consideration of Mr. Hamady's note. There wasn't an awful lot the judge said he could take from it, but he said he did accept that the prominence here was more than negligible and the version was less than expected, and as a result the version of the socket caused the component to be prominent. The evidence from Mr. Manctolo for the defendant was that when you're performing this particular surgery, if there is any prominence, you can feel it. You can run your finger or an instrument along the cup, and you should be able to feel whether there is any prominence there. And Mr. Manctolo described, and this is at paragraph 31 of the judgment, that he'd seen prominent acetabular components quite frequently on a number of occasions, both quotes there. He told me that a number of surgeons make this error because surgeons are not as careful as they should be to ensure that the socket is deep to the anterior bone. So the judge said what he took from that is that some surgeons undertaking the arthroplasties allow the component to stand prominent, so there's a body of surgeons who don't ensure that the component is placed in a position such that it doesn't interfere with the iliopsoas tendon. And secondly, that Mr. Manctolo was critical of their conduct by using the word error and not as careful as they should be. Mr. Chatterjee's evidence was fairly similar to Mr. Manctolo's in that he said you could run a finger round the component to feel if it was prominent. Equally, you could run an instrument along it as well. He said that here there was no anatomical or surgical reason for the prominence, and that he thought there was a breach of duty. He also said, and this wasn't challenged, that actually once you've realised there is a prominence, redoing that part of the surgery so that there is no prominence is relatively straightforward. Interestingly, at paragraph 37, the judge was discussing Mr. Manctolo for the defendant's evidence. Mr. Manctolo did not concede that there was a breach of duty. And what the judge said is, I felt that Mr. Manctolo did not explain satisfactorily why what Mr. Cope did was not in breach of duty. He said he plainly thought that a surgeon ought to avoid prominence of the acetabular component. He did not offer a justification or rationale for neglecting to ensure that the component was not prominent. In the last sentence, I was left with the impression that Mr. Manklow's justification for asserting there was no breach of duty was because he said so. Paragraph 41 is where he talks about the actual conclusions himself. He found firstly that there was a body of surgeons undertaking the hip arthroplasties that holds the opinion surgeons should ensure that the component is not placed in a prominent position, and both Mr. Chatterjee and Mr. Manklow subscribed to this view. He said in particular, Mr. Cope would have been able to visualise the component or use an instrument or finger to feel it. There was no surgical or anatomical reason why the component could not be placed in a prominent position. And then thirdly, as Mr. Chatterjee pointed out, it was a straightforward matter to replace the component, or remove the component, and replace it if needs be. And ultimately, paragraph 44, he said, I reached the conclusion there was no logical basis for neglecting to ensure the component was not placed in a position that could interfere with the iliopsoas tendon. And the judge relied on that. He said there's no good reason been advanced for not taking the precaution. He said it would be relatively easy to visualise, relatively easy to feel with an instrument or a finger. If there was any risk in placement of the cup, it was relatively simple to remove it. And essentially there was no surgical or anatomical reason for running the risk in this particular case.
That's great. Thanks very much, Charlotte. David, the judge took an interesting approach to Bolam and Belitho in this case, and I wonder if you could set out that approach in a little bit more detail for us.
Yes, thank you, Neil, and thank you, Charlotte. It should be remembered that in this case, the judge was confronted with a situation where it was being said that although the expert for the defendant wouldn't have done what the defendant surgeon did, that kind of practice went on and therefore it was all right. And that was the problem that the judge was confronted with. And that exposed the problem with the Bolam test that has crept in over the years, which does cause, in my experience, expert witnesses a lot of concern. Experts are confused by the difference between Bolam and Belitho. And I think that this judgment is useful in clarifying it and giving experts further reassurance and further courage in the conviction of what they're saying. I tend to explain Belitho to experts as follows. I begin by explaining the Bolam test, which, as we all know, is that a procedure is not negligent if it accords with a reasonable body of opinion within the profession. But I say that has made it too easy for defendants over the years, because all that the defendants have to do is get an expert to say that this practice goes on and therefore it can't be negligent. But that's a bit like saying that because people speed on the roads and because people think that's okay, speeding is not careless. Well, that can't be right. And really, Belitho put a stop to that kind of tendency by saying that just because a practice goes on, it doesn't make it right. And if that practice is not reasonable or does not stand up to logical scrutiny, then it no longer is a reasonable practice and it is not representative of a reasonable body of opinion. So in effect, Belitho is a reaffirmation of Bolam in the difficult cases where bad practices go on and are tolerated. And that's precisely what the judge recognised in the case that we're discussing today. And he said at paragraph 43, I think it was, that the two schools of thought in this area, the school of thought that said that you should check the sighting of the cup in the hip joint and the school of thought that said that you shouldn't, both should be examined under the Bolam and Belitho tests. And the test that should be applied under both is whether those schools of thought are logical or not. And the judge came down in favour of finding that the school of thought that said that you don't need to check the sighting of the cup was illogical and cannot be sustained and is therefore negligent. And that's an important point in favour of claimants in cases like this. And two further points emerge from that judgment, which I think are quite interesting and of significant practical effect. The first is that the defendant surgeon, Mr. Cope, was never taught to check for the sighting of the cup. But in spite of that, the trial judge said that he was negligent in not checking for the sighting of the cup, because Mr. Bradfield-Kay was entitled to a reasonable standard of care, and that included checking for the sighting of the cup. The second important feature of this case, I think, is that Mr. Chatterjee, who, as Charlotte said, was the less experienced expert, expressed an opinion which was preferred by the trial judge, notwithstanding that he couldn't back it up by any reference to anything in a textbook. And that's quite significant, because what the judge was effectively saying is that Mr. Chatterjee has explained in his own words why a practice or an omission is illogical, and I accept it in the facts of this case, and therefore I find for the claimant. And I think that those 2 points are of great significance and assistance to claimants in these sorts of cases. Neil.
David, that's really helpful. And perhaps bringing this all together, having considered and heard the case, I just would like to invite your views on the consequences of this judgment for lawyers when considering who to instruct as experts. And perhaps if I can start with you first, David.
Thank you, Neil. So following on from the point I just made about the weight that the judge attached to Mr. Chatterjee's own logical explanation, I think that that offers reassurance to expert witnesses who think that a act or omission is negligent, but they can't back it up by reference to textbooks or authorities. And sometimes, I should say articles rather than authorities, and sometimes we come across experts who say, well, I think this is not right, or I think this point of causation is sound, but I can't back it up by reference to a learned article or a textbook. And I often say to experts, well, an ounce of experience is worth a ton of articles, because you can rest assured that if you cite an article, the defendants will find one to counteract it. And accordingly, if an expert can justify his or her position from his or her years of clinical experience, in my view, a judge will attach more weight to that. And that's borne out by this case, in that the judge was prepared to accept Mr. Chatterjee's view, even though he was less experienced and even though he couldn't back up what he was saying by reference to any learned articles. And in that regard, I think it will make the instruction of experts a lot easier, and will give them a fair degree of confidence in what they're saying.
Many thanks, David. Charlotte, when we've talked about this case previously, you'd raised some interesting points. Would you like to set these out for us?
Yes, I suppose the takeaway I come from is choose your words carefully. So Mr. Manctolo was criticised for not being able to justify his position that he thought that there was a breach of duty. And that the judge seemed, this is particularly paragraph 31, to take great stock in the fact that, it's the quote I read out, a number of surgeons make this error because surgeons are not as careful as they should be to ensure the socket is deep to the anterior bone. And the judge used that to say, well, Mr. Manctolo is critical of the conduct. And then at the end of the sentence, he puts in brackets, as demonstrated by the use of error and not as careful as they should be, which perhaps undermined the point that Mr. Manctolo was making when he says, well, it's not negligent to be doing it. It's one thing to say, well, my practice is slightly different to the practice that was occurring in this situation. But there's a fair degree of implied criticism from Mr. Manctolo there when he's using words like error, that there's a negative connotation there. So it's to come back to that point, well, just be careful about the way that you word things, because it appears here that those use of the words error may have come back to bite him to some extent.
Brilliant. Many thanks, Charlotte. Andrew, what's your take-home message?
Thank you, Neil. Well, my take-home message is effectively that experts need to be able to show their reasoning in these sorts of cases. And we see it particularly with Mr. Manctilow's case and his explanation of why Mr. Cope's actions were not negligent. But we see at paragraph 37 where the judge says, "I was left with the impression that Mr. Manctilow's justification for asserting that there was no breach of duty was because he said so." And it's really important, and it's part of the distinction between Bolam and Blytho, that if there is a body of medical opinion that supports a practice, that the expert is able to say why that practice is preferred and why that's chosen over another form of practice. And perhaps the key reason why the claimant succeeded in this case is that Mr. Manctilow wasn't able to say why it was okay for Mr. Cope to not check the component when it would have been fairly straightforward for him to do so. So yes, show your reasoning would be my takeaway from this particular case.
Excellent, thank you, Andrew. That's been a really interesting discussion to look at the challenges that have been brought up from this case, how experts are approached by the court. And I'd like to thank our panel of David Tyack, Charlotte Robinson-Jones, and Andrew Rhodes for taking the time to speak with us today. All that's left to say is that there are a series of vlogs and podcasts on the No5 website. There will be more coming out in the series from the clinical negligence and personal injury groups, and I hope that you find them useful and interesting in the future. Many thanks indeed for joining us.